Okay, if I could have you both unmute, please. All right, Mr. Caverson, are you able to hear me okay?
Yes.
Okay, Ms. Caverson, are you able to hear me?
Yes.
Okay, we're on the record in Caverson versus Caverson. This is case number 2419737. Record should reflect both parties are present today by Zoom video. This is set as a pretrial hearing in this case. Typically what I try to do is just determine what kind of hearings we need to set going forward to get this matter resolved. A lot of that depends on whether the two of you have been able to, reach agreements in terms of dividing up any assets or debts of the marriage. Mr. Caverson, as the plaintiff here, can you tell me whether there are issues in dispute or whether you've been able to reach any agreements?
I don't know of any issues. We were actually wanting to ask you, we're thinking about, or we are trying marriage counseling tomorrow. We didn't know if we could possibly extend to see how that goes or what our next steps would be.
Yep, so there is a way to kind of put the case on hold for up to 6 months. It doesn't have to be that long, but it can be up to 6 months. I just need for one of you to file with the clerk's office, just something in writing indicating that you'd like to put the case on hold to try and reconcile. The benefit to that is if you decide later on that you want to go forward with the divorce, you don't have to repay the filing fee. And then if you are able to reconcile, then you just need to notify the court and we can dismiss the case. So that's an option if you do that.
Okay. I think that's what we were talking about, trying that.
Okay. Ms. Caverson, is that how you wanted to go forward?
Yeah, that's okay.
Okay. So either of you at any time during that 6-month period can notify the court and say, look, I want to go forward with the divorce. You don't have to agree to it. Just one of you needs to decide you want to do that. And then the court can put it back on the docket. So I'm just going to have the file reflect that you're going to file a notice of reconciliation, and then the court will set this for a hearing in about 6 months, unless one of you notifies us earlier than that. Mr. Caverson, do you have any questions about that?
No, I don't.
Ms. Caverson, do you have any questions?
No, I don't. Thank you.
Okay. All right. Thank you. That's all for this hearing today, and you're both free to disconnect.
All right. Thank you.
Okay. Mr. Blumberg, do you have Ms. Carr with you?
I do not. I didn't think she was going to be here today. We're simply asking the court today is to enter the default, and then we would prepare a default judgment and have a hearing at that time, Judge.
Okay. All right. Let's see. Okay, for the record, this is Carr versus Carr, case number 2419798. Mr. Blumberg's here on behalf of plaintiff Ms. Carr. Neither of the parties have appeared today. It does appear that Mr. Carr was properly served with the summons and complaint back in August, that he did not file any kind of answer, otherwise defend. It does look like there was a default entered back on October 28th, so I think anytime, Mr. Goldberg, that you want to schedule for a final hearing with the court, that would be appropriate.
Very good, Judge. I wasn't aware that you had signed that. My fault.
Actually, I think it was the clerk that entered it.
Okay.
So
I
we're
guess
good to go.
Yep.
We'll just wait. We'll just wait for you to set it for hearing.
Thanks very much.
Okay, thank you.
Bye.
Okay, it looks like we've got one more joining in. Okay, great. Looks like we have everybody connected, so we'll go on the record now in Kent Family Farm versus Vaughn et al. This is case number 2419708. We have Mr. Slough present on behalf of plaintiffs. We have Mr. Shimovitz here for defendant Vaughn, Mr. Norton for Tolo Trust and Youns, and Ms. Pretzlos. You're here on behalf of MERS, is that correct?
That's correct.
Okay, so we've got everybody connected. This is set up as a status conference today. I did receive a mediation report from late November indicating the parties did participate in mediation, did not settle, but perhaps are considering further negotiations. Mr. Slough, on behalf of plaintiff, can you kind of tell me where things are at from your perspective and what you would like to see today in terms of scheduling going forward?
Sure. The parties did attend mediation. I think we had a productive conversation. The defendants, particularly Mr. Vaughn, needed some more information before continuing with mediation, and so the mediator proposed to adjourn it. And we have already set another date on January 15th to continue with mediation. So that is where the parties are at. I think at this point, it would make sense to just set a status conference for after that January 15th date and just leave discovery open. And we can prepare to try to resolve this at the next mediation session.
All right, thank you. Mr. Shimovitz?
Yes, sir. Mr. Slough has accurately reflected our history and our agreement.
Okay. Mr. Norton?
Yeah, agreed. That's accurate.
Okay. Ms. Pretzlos?
Agreed, Your Honor.
Okay, then I think that's a reasonable way of going forward. So the court will set this for a status conference probably early February. We'll do it by Zoom just as we're doing today, and we'll check in then and see where things are at. Is there anything else that I can address for any of you while we're all here today?
Nothing for the plan.
Judge, can we look at dates in early February, maybe? I know I'm going to be out of country for one of those weeks, so selfishly, I'm interested in what that date might be.
It'll be my first motion day of the month, which is the first full Monday.
We have the 3rd.
It would be February 3rd.
Okay, that's cool. The 10th, that would not work, but thank you. I just thought I'd try to get out of the way, something to avoid a whole stip in order motion thing.
Sure, thank you. Anything else? No. Okay, thanks, counsel. Everybody's free to disconnect.
Okay,
Thank you.
thank you, Judge. Have a good day.
right, we've got somebody on the phone. The last four digits are 2670. Can you tell me who you are, please?
Hi, this is Rachel View.
Rachel View?
Yes.
Oh.
Is this Mr. Mertz, Your Honor?
Yep, you're in the right spot. I just couldn't quite hear
Okay,
you.
sorry. Sorry,
No,
I
you're good.
apologize.
Okay, so I'm bringing in the other parties on your case here. Just give me 1 second.
Thank you.
Okay, Mr. Pelfrey, are you able to hear me okay?
Yes, Your Honor.
Okay, and Mr. Kadat?
Yes, good afternoon, Judge.
Okay, good afternoon. We're on the record now in Rachel View versus Tyler Pelfrey, case number 2419831. The record should reflect that Ms. View is present by Zoom along with her counsel, Mr. Kadat. Mr. Pelfrey is also present by Zoom. This is set as a pretrial hearing in this case to set some dates for going forward. Mr. Kadat, on behalf of plaintiff, can you tell me what you would like to see for scheduling to get this resolved?
Yes, Your Honor, thanks. So the remaining issue is really just the retrieval of my client's personal property, premarital personal property. It is a very short-term marriage. The property is presently located in and about Mr. Pelfrey's home, and we have an agreed upon list of items that my client is to retrieve, and they've been working on it, but due to unfortunate circumstances, it hasn't all been retrieved yet. So what I would propose, if the court permits, is to take final proofs from my client and Mr. Pelfrey that we can preserve for the record and adjourn the pretrial to a status conference to be set in about 45 days to give my client additional opportunities to retrieve her premarital separate property. There is no marital property. There is no marital debt. It should be a very simple divorce judgment once it's all done.
Okay, Mr. Pelfrey, were you able to hear that?
I was, Your Honor.
Okay, do you have any objections to anything that Mr. Kadat has indicated?
No, Your Honor.
Okay, all right. So Mr. Kadat, did you want to take proofs from your client today?
Yes, please, Your Honor.
Okay, so Mr. Pelfrey, what we're going to do for purposes of today's hearing, the court has to take certain testimony from each side to establish the grounds for divorce under Michigan law. So we're going to do that, and then that might eliminate the need for either of you to have any further hearings going forward, okay?
Yes, Your Honor.
Okay, so we're going to start with Ms. View, since she's the plaintiff. Ms. View, wherever you're at, can you raise your hand, and can you let me know once it's raised, please?
Yes, Your Honor.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, Your Honor.
Thank you. You can lower your hand, and Mr. Kadat, proceed whenever you're ready.
Rachel, will you state your name for the record, please?
Rachel Mayview.
And Rachel Mayview, did you file a complaint for divorce against Tyler James Pelfrey on or about September 6, 2024?
Yes, Your Honor. Oh, sorry.
And at the time that you filed the complaint for divorce, Ms. View, were you a resident of Michigan for 180 days and a resident of Otsego County for 10 days?
Yes.
And did you marry Tyler James Pelfrey on May 4th of this year before an individual license to perform marriages in Otsego County?
I'm not sure about the county, but it's close by.
Okay. Was it in the
Sorry.
state of Michigan?
Yes.
And do you have any minor children born or adopted during your marriage?
No.
Are you currently pregnant?
No.
Has there been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved?
Yes.
Is it true that no marital property was accumulated since the date of your marriage on May 4th?
Correct.
And have you reached an agreement as to your separate items of premarital property that you will be retrieving from Mr. Pelfrey's home?
Yes.
Is it your wish that your maiden name be restored to Rachel May Allen?
Yes.
And is it your wish upon submission of a signed consent judgment of divorce to the court that the court enters such judgment to finalize your divorce?
Yes.
I don't have any other questions for Ms. View, Your Honor.
Thank you. Mr. Pelfrey, could you raise your right hand, please?
Yes, Your Honor.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can lower your hand. Mr. Pelfrey, we're able to hear all the questions that Mr. Kadat asked of Ms. View.
Yes.
Were you able to hear all of her answers?
Yes, Your Honor.
Do you have any reason to believe that any of the answers she gave were untrue?
No, sir.
Have you been living in Otsego County for at least 10 days?
Yes, sir.
How long have you lived in Otsego County?
Since 2006.
Okay, thank you. Do you agree that you and Ms. View have agreed on the property that's going to be divided up between the two of you?
Yes, Your Honor.
Okay. All right. Thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court will grant the divorce. I will sign that judgment once it's been presented. The court will set this for a control date status conference at about 60 days out. If for some reason there's been any hangups between now and then, we can address that. Mr. Kadat, do you have any objection to that?
No, thank you, Your Honor.
Mr. Pelfrey, did you have any questions or concerns?
The only thing I would like to make clear and make sure that I do understand is that after the remainder of her property is collected, the portion of the mutual restraining order that allows her to come to the residence will in fact be void after that. Once she retrieves her property, there'll be no further admittance onto the residence. Is that correct?
Mr. Kadat is, I gotta look at the order.
Oh, yep, I have to look at it too, Judge. So, paragraph section 2 of the temporary mutual restraining order does specifically indicate that the parties must cooperate to facilitate plaintiff's removal of her remaining personal property from defendant's home. That's the only exception listed in the mutual restraining order allowing my client entry to the home.
And so it is my understanding after the removal of that property that mutual restraining order would then prohibit her return to the property after her belongings are removed, correct?
So,
Yeah, so
oh, go ahead, sorry.
okay. No, I was going to say, I'm looking at paragraph 2, sub B, which says plaintiff may not appear at defendant's home unless a particular date and time is agreed by the defendant. So to me, what that says, Mr. Pelfrey, is she can't come to your home unless you agree to it once her property is retrieved. So, you know, if you allow her onto your home, that's one thing, but I don't think under that order she would be permitted otherwise to be on your property. Mr. Kadat, do you agree with that?
I do, Your Honor. Yes, thank you.
I appreciate the clarification. That was my only question. Thank you, Your Honor.
Okay. All right. Thank you. That's all for today. All parties on this case are free to disconnect at this time.
Thank you.
I can't hear you.
Hear me now?
Yes, I can hear you now.
Okay.
He's having a hard time getting on his computer.
Okay. I did see Mr. Mortgage signed on. I don't know if he got disconnected, but I don't see him right now. He was here a minute ago. So I'm just gonna have you just wait for a minute and see if he reconnects, okay?
Okay.
Oh, wait a second. Here it is right now.
Okay.
Looks like he's slow to connect here, so if you can just stay on the line here.
Yeah. I'm not going anywhere.
Mr. Mortgage, I'm not sure if you can hear me or not, but you may have to connect on a different device or do something different, but I don't have your camera, nor do I have any kind of audio for you this time.
Can you hear me?
I can, I'm not
Try
sure why.
It kicked us all out. Well, I don't know why. It shut down my computer and then it popped back on. I don't know what happened there. And then his computers froze.
Okay. Well, I mean, I can't go forward without both of you being present. I'm willing to try and bring you
Can
in.
you do
on a
him
different-
auto? I mean,
What's that?
can we run in there? Can we come in and meet with you?
All my hearings today are by Zoom, so I don't have anybody who could let you in. So if you want to continue to, if he wants to continue to try to connect, I can try and bring you both in again later today. I can try and schedule it for a date when I'm having in-person hearings here in court.
We want to get it done today.
Yeah, I totally get it, and I'm willing to continue to try today if you want. I see Tim up there, but it's just not connecting, so.
Can you use the computer at your work or no? Yeah.
Probably can, but I'll have to go back to work.
If he has access to a phone, I mean, he can just sign in, you know, with his phone.
He said his phone's freezing up. Can you try on your phone?
I can try on my phone. I have Zoom on my phone.
You gotta put the app on your phone.
Or if he just wants to call, you know, we can try having him call my office, and my secretary or my assistant Jennifer.
Nobody's is there a different number? Because I tried that number because I wasn't connected with you. And nobody answered that phone. The 731-7500.
Yeah, have him try 731-0224.
0224. Did you hear that, Tim?
Yeah, can I try that?
Yes. 989-7.
Number right here, I'll call it.
Okay. Okay. All right. Like. Okay, he's gonna try that number.
Okay.
Oh, I see it at the bottom. Have you been having problems with others or?
Not really. Not these kind of problems. Problems. Hello?
Hi.
Hi.
So I have Tim Mortridge on the line. Do you want me to transfer him up to you?
Yes, please.
Okay, he'll be there when I hang up.
Okay, thank you.
Thank you.
All right, Mr. Mortgage, are you able to hear me?
Yeah, I'm here.
Okay. All right, so we'll go on the record now. This is Mortgage versus Mortgage, case number 2419851. We have Mr. Mortgage present by phone and Ms. Mortgage present by Zoom video. I know Ms. Mortgage is ready to go. Mr. Mortgage, were you ready to proceed with finalizing the divorce today?
Yes, I am.
Okay. So, Mr. Mortgage, if you can raise your right hand and let me know once it's raised.
Yeah, it's raised.
Miss Morgridge, can you raise your right hand? Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes.
Okay, thank you. You can both lower your hands. I'm going to ask each of you a series of questions. The questions that I'm going to be asking you are those that I'm required to ask to establish the grounds for divorce under Michigan law. Mr. Morgridge, as the filing party, you filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes.
At the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Otsego County for at least 10 days?
Yes.
In the complaint, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remain no reasonable likelihood that the marriage could be preserved. Was that true when you signed that complaint?
Yes.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
And there is with this, first of all, you signed this judgment of divorce back on September 24th, is that correct?
Yes.
And that judgment provides for disposing of some real property on West Street in Gaylord, is that correct?
Yes.
And then there was a separate two-page document that you both signed that discusses how that's going to be divided up and places a time limit on how that's going to happen. Is that correct?
Yes.
And are you asking the court to adopt all of those things as the conditions of your divorce?
Yes.
Okay. And outside of that, you've already divided up all the other property and debts between the two of you. Is that correct?
Yes.
Okay. Thank you. Ms. Morgridge, have you heard all the questions that I asked Mr. Morgridge?
Yes.
Were you able to hear his answers?
Yes.
Do you have any reason to believe that any of the answers he gave were untrue?
No.
Are you currently pregnant?
No.
Okay. And you signed that judgment of divorce in that separate document, two-page document regarding the real property. Is that correct?
Correct.
And are you asking the court to enter this divorce based on those terms?
Yes.
Okay. One last question, and this applies to both of you. Mr. Morgridge, under the divorce, you're not going to receive any alimony or spousal support. Is that correct?
Correct.
You understand that you would be waiving that forever. You would not be able to come back later and ask the court for that.
Yes.
And Ms. Morgridge, you're also not going to receive any alimony or spousal support, correct?
Correct.
Similarly, you understand that you would not be able to come back later and ask the court for that.
Correct.
All right. And Ms. Morgridge, are you asking to have your last name changed?
No. I'm going to keep it Morgridge.
Okay. The court finds that the statutory grounds for divorce have been met by the testimony of the parties. The court will grant the divorce. I've signed that proposed judgment, so your divorce is final as of today. If either of you would like a copy of the judgment for your records, you can get that here at the clerk's office. Mr. Morgridge, do you have any questions?
No, I do not.
Ms. Morgridge, do you?
Yes, it's about getting copies because we
Yes.
want to go and finalize everything we agreed upon and we need the judgment of divorce to do so. And the ladies told me that I couldn't get it until morning.
I don't know.
How quickly I can get it done.
Yeah, I mean, do you think can we get that?
I can work on it as soon as we're done here.
Okay, so they're gonna they can try and get that done today. I've signed it.
Okay.
It's just a matter of getting that entered into the system and filed.
Right. Right.
Yeah, so they're gonna try and do that. If you want to call up maybe a little bit later towards the end of the day and see if they've been able to do that.
Okay. Thank you very much.
Okay. All right, thank you. That's all for this hearing, and you're both free to disconnect.
Okay. Thank you.
Okay, Mr. Slough is present. We'll go on the record. This is Race versus Summers, case number 2419842. The record should reflect that Mr. Slough is present by Zoom on behalf of plaintiffs. This hearing was set for 2:15. It's now almost 2:30. No one has appeared on behalf of the defendants. And this is a motion for entry of default judgment. Mr. Slough, is there anything that you wanted to state for the record in support of your motion other than what you filed in writing?
No, it's a straightforward, quiet title for a defect arising out of a tax sale and failure to give the owner at that time notice of the sale. My client's been in possession of the property for some time, and there's never been any indication from anyone that they're asserting any type of interest in the property. The only thing I would add, Judge, is that I put the correct case number, but the year is wrong on the case number. It's not 23, it should be 24. So if you wouldn't mind correcting that on the proposed judgment we submitted.
Okay, I've made that correction. And then the record should reflect the court did review the file. It does appear that the defendants were properly served pursuant to the court rule. Again, no one has appeared today to contest entry of the judgment, so the court will sign that. And anything else that I can address for your side today?
No, thank you.
Okay, thank you. That's all for today, and you're free to disconnect.
Thank you.
All right, looks like we've got everybody connected. We'll go on the record in, let's see, Tresha Smith versus Bauer. This is case number 2319444. We have Ms. Bailey Quick present on behalf of the plaintiffs and Ms. Alspaz present on behalf of the defendants. This is set as a status conference today. And Ms. Bailey Quick, can you tell me where things are at from plaintiff's side, please?
I'm sorry to interrupt, Your Honor. I'm actually not defendant. I'm not the defendant's attorney. I'm here on a different case.
Oh,
I'm here for Ally
sorry.
Bank. No worries.
Okay. Sorry about, and you know what? You even put the case number and everything on there, and I still didn't pay attention. So
That's
sorry
okay.
about that. Okay, I'm going to put you back in the waiting room for just a moment then.
Thank you.
Okay, Ms. Bailey, quick, have you had any contact with defense counsel in this case?
I haven't. He did. I was hoping he was going to be on because he did also appear for our probate hearing. We successfully had that hearing. The orders were signed by Judge Cooper, and I believe I'm just waiting on. I prepared a proposed release and settlement, but I'm not sure if that meets with their. I attached that to the probate pleadings. I'm not sure if that met with their necessities on their end. So I'm just waiting to hear from them and receive the check and enter the final dismissal.
Okay, I mean, is there need for any further hearings by the court?
I don't think there's a need for any final hearings. If perhaps, if the court wants to just set it for, monitoring, maybe for just a telephone conference in 30 days if we don't have it. I know the hearing was on November 5th. We didn't get them immediately. Judge Cooper did ask for a couple of revisions, and so maybe just with processing time, but I think we can have this wrapped up.
Okay, so I think that's what I'll do then. I'll just set it for like a control date status conference. If we get the closing documents prior to that, the court will just take it down, and if not, then we've got another date to check in on.
Okay, sounds good. I hopefully we won't have to see you, Judge, but on this case anyways,
Right.
I think we're very close and we can get it wrapped up.
Okay, all right, and then I'll just note for the record that defense counsel didn't appear today, and you and your client are free to disconnect.
Thank you.
Thanks. Okay, now we're on the record in Ally Bank and Trust versus Cooper. This is file number 2419679. And Ms. Alsabat, you can put your appearance on the record so I don't mess it up.
Thank you. Good afternoon, Your Honor. Rita Elsbach, P87060, here on behalf of Plaintiff, Ally Bank Lease Trust.
All right, and this is a date and time set for entry of a default judgment. And I did have a chance to review that prior to the hearing today. Is there anything that you wanted to state for the record in support of your motion?
Nothing in addition to what's on the motion, Your Honor.
All right. Right, the court again had a chance to review the file and the motion prior to the hearing today. Defendant was properly served pursuant to court rules. There was no answer, appearance, or otherwise effort to defend the case. The court notes that this matter was also set for hearing at 2:30 today. It's now 2:37, and no one has appeared here to defend the case. So the court finds that the judgment is appropriate. So I'll sign that with today's date. Also, about anything further that I can address for your side while we're on the record. Okay.
Nothing further for the record, Your Honor. Thank you.
Okay, thank you, and you're free to disconnect.
Thank you. Have a good day.
Thank you. Sir, can you unmute and can you tell me your name, please?
Yep. My full name is Elijah Miguel Cobb.
Can you say that again? Can you say your name again, please?
My full name is Elijah Miguel Cobb. Yes, it's Elijah Miguel Cobb. Do I need to enunciate more, or is it?
No, your signal just isn't coming through good. That's all. It's kind of breaking up, but I got it.
Okay.
So thank you. Yep. Okay. Okay, we have Mr. Slough connected. So we'll go on the record. This is Skronsky versus Savo Valley Forestry Service, Stephen Cobb, Eli Cobb, case number 2419709. The record should reflect we have Mr. Slough here on behalf of the plaintiff. We also have Eli Cobb present, both by Zoom. Mr. Slough, this is your motion for entry of default judgment in this case. How did you want to proceed today?
Well, we have, first of all, Judge, submitted an administrative closing as to Eli Cobb. He is in a Chapter 7 bankruptcy in the Western District of Michigan. And I believe the court has entered that, so he has been dismissed, subject to that bankruptcy stay. So we would be requesting today entry of default as to the remaining defendants being Stephen Cobb and Osable Forestry Services.
Okay. Mr. Cobb, is there anything that you wanted to state regarding that?
No, I'm here as a representative of Osable. Right now, Steve can't get his phone to work with Zoom, so that's why he's not present. I guess moving forward, I'm not certain as far as to, because I had submitted a terms of settlement on my behalf. So I am just waiting on the response for that.
Okay. And I mean, you're free to make a record, you know, with regard to the extent these claims affect you personally, in terms of representing Savo Valley LLC. You know, that's a separate business entity, and so you can't speak on behalf of them. You would have to have an attorney to do that. Unless you're a licensed attorney, of course.
No, no, that I am not.
Okay. All right. And I think, you know, to the extent that you want to discuss the claims that are made against you personally, that's something you're more than welcome to do with regard to Mr. Slough. But I'm looking at the file, and Mr. Slough's correct. I mean, the case as to you personally has been closed because of your bankruptcy filing.
Okay.
Yeah, and sir, just to the extent you maybe have made an offer through your attorney or want to discuss some sort of resolution.
Sorry.
I'm sorry, just to the extent that
my
maybe
signal cut out, I can't hear you.
Just to the extent that you maybe have made an offer through your attorney or would like to make an offer, it's got to go through your attorney in the bankruptcy simply because of that bankruptcy stay that's open. I can't talk to you or
okay,
you know, try to negotiate with you directly.
Yeah.
So it's got to go through your attorney.
Okay.
But I appreciate that.
Yeah, I am just wanting to move forward with my life at this point. So
yeah.
Yeah. So as a behalf of Osable and as on behalf of Steve, I cannot make any legal.
Yeah, you don't have to say anything,
because
sir,
there's no
on
attorney
their
present
behalf.
for
I
either one.
appreciate that.
Okay.
Yeah.
Okay.
All right, then, Mr. Slough, in terms. Go ahead. Mr. Cobb, did you
Oh,
have
no,
another
I'm
question?
sorry. Go ahead.
Okay,
I do
Mr.
not know.
Every time I start talking. All right, Mr. Slough, in terms of the default, is there anything that you wanted to state for the record other than what's in your motion?
No, Judge. I think the motion sets it forth.
Okay, so I reviewed the file. I also reviewed the motion prior to the hearing today. I think as to those two entities, or that entity and that individual, that is appropriate. So the court will sign that with today's date. Mr. Slough, is there anything else that I can address for your side?
I guess I will just make a record of one thing very briefly, Judge. And I think there was maybe a little confusion with the court staff because there was another file opened initially and we didn't get service in time or get an extension of the summons date. And so the second case was opened up immediately following the closure of that first case. There was a note that I got from the staff that there was a notice of pending dismissal for lack of progress. And I think maybe they were referring to the first case, not the second case. And that's why I filed the motion for default judgment, was to address that. The clerk had actually already entered a default with a judgment sum certain because there was a certain amount set forth in the complaint. So really this motion was unnecessary, but we did it again to address the pending understanding of the court staff that the case was going to close without further action. So we did this just to get a final order entered that closes the case up.
Okay. All right, thank you for that clarification. That's all I have for today, and all parties on this case are free to disconnect at this time.
Great, thank you.
Your Honor, I do have one question.
Okay.
You signing off on the default judgment, or is that for the treble damages as well? Is that all inclusive?
Yes, it is.
Okay.
Yeah, the total amount of the judgment is $100,200.
Okay.
Yes, and if you'd like a copy of that for your records, you can contact the clerk's office here and request a copy.
Yeah.
Of that judgment.
Yep. Okay. Thank you, sir.
Okay. Thank you.
Yep. Bye.
Okay, looks like we have counsel connected, so we'll go on the record. This is Brandt versus Shorefire, case number 2419855. And if I could have counsel put your appearances on, starting with plaintiff, please.
Thank you, Your Honor. Isaac Post for the plaintiff.
Alyssa Kennedy, Your Honor, for the defendant. Thank
you. We're on the record here today for purposes of pretrial scheduling order in this case. Mr. Post, can you just kind of give me just a brief outline of your claims as well as what you'd like to see for scheduling going forward?
Yeah, thank you, Your Honor. I mean, the basics is Ms. Brandt was in a car accident and suffered some injuries. She's been having pain in her back primarily. no surgery as of yet. She has had injections. As far as what I'm looking for today, obviously we got to have some time for discovery. Mediation, I would certainly be open to doing some sort of mediation in the future. Probably have to have some depositions at some point. I can get more specific if you want, Your Honor. I don't know. Sometimes there's an order that the judges want to go in, and sometimes they don't. So I don't want to just start, rattling off stuff if you have a specific order you want to go through.
Okay. All right. Thank you. Ms. Kennedy, what's the defense here? Are you contesting liability and damages?
At this point, we are, Your Honor. That obviously might change. At this point, we're disputing both. I think this is a pretty standard case, and we would just request the standard discovery for it.
Okay. Either do you have an object? I mean, is 180 days enough? I don't know how much medical there is here.
There's not a crazy amount of medical, Your Honor. 180 days, I would think that would be enough, especially if, I'm not saying we're striving to have a bunch of adjournments, but, it sometimes happens as long as Your Honor's okay with, an adjournment if we can't quite get everything, but that's not what we want. We want to get the information changed and exchanged, and then maybe have mediation or something is what I would like to do.
All right, Ms. Kennedy, any objection to 180 days?
180 days is fine, Your Honor. Thank you.
Okay. All right, so let's say 180 days, parties to have mediation within that time. Have you both worked together? Do you think you'd be able to agree on a mediator?
We have not worked together,
Yeah.
but I can't imagine that we can't agree on a mediator. I've never had any issues doing that before.
Okay, so the court, I'll send out a pretrial order, but it does require the parties to confer and notify the court of your selection within the next 14 days. And then mediation to occur within that 6-month period. Mr. Post, from your standpoint, as it sits now, any need to amend pleadings or add any parties?
No, Your Honor.
Ms. Kennedy?
No, Your Honor.
Okay. And Mr. Post, any objection to a dispositive motion 30 days after the close of discovery?
No.
Dispositive motion. Okay. Ms. Kennedy?
No, Your Honor.
Okay. And then I will set this for a status conference at just following the close of discovery. And if the case did not resolve through mediation, then we can talk about further scheduling. If there's dispositive motions set for hearing, we can discuss that as well. Mr. Post, any other dates that I can address for your side today?
No, Your Honor.
Ms. Kennedy?
No, Your Honor. Thank you.
Okay, I'll put this into an order. I'll send that out to the parties along with notice of the date and time for that status conference following the close of discovery. And you're both free to disconnect. Thank you.
Melissa, can I give you a call?
Sure. Go right ahead.
Okay, great. Thanks.
Thanks.
Right, and that concludes the court's YouTube docket for today.